Prospective client call. The will was changed. Then we proceeded to talk and have a discussion about what awareness do you have of the will? Where is the will? Has the will been produced? What do you mean the will was changed? And really the circumstances are that an older relative, let's use grandfather, had a will. Grandfather was a widow and had 2 children. The belief by one of the children is that a house and property and some assets were going to be divided into 50-50. And in fact, and this person passed away in the last 2 months. 3 years ago, the property was transferred from the deceased person. They were alive at the time, right? They just passed away now, but 3 years ago, the property was transferred from that person to one of the children, not the person that called me. And that property was then transferred to someone else. So there were 2 transfers. Well, the will wasn't changed, but the actions of the testator, the decedent, the person that made the will, the actions of that person frustrated the will. It defeated the will because they didn't own the house at the time of their passing. So if I say I own a property 123 Main Street and I'm going to give it to Jane Doe, so in the event that I pass away, 123 Main Street goes to Jane Doe. Now, if during my life I sell 123 Main Street, there is no 123 Main Street to give to Jane Doe. So what I did was I frustrated the will. I defeated the purpose of the will, and Jane Doe is out in the cold. So is there a will to be presented? Is there a potential litigation? Well, we need better facts. We need more information and we need better facts. Was the grandfather deluded? Did he have a capacity to transfer the property? Did he transfer for market value? Did he transfer the property relying on his child to take certain steps? These are all circumstances we don't know, but this is probably not a surrogate's court case because there is no asset, at least this given asset, the property, that asset has not been in the person's name for 3 years. Could be a Supreme Court case, could be a constructive trust, could be a litigation. Maybe we file something to set aside the deed. There are potentially things we could do. We need better facts. This is a call I received today, and I'm presenting that information now. But a lot of people, they start the call with one frame of reference. Oh, the will was changed. In this case, the will was not changed. The circumstances that surrounded the will changed.
I had a consult yesterday with an adult woman that was discussing the situation of her parent. And I'll tell you, it was her father. And she let me know that he's deeply concerned that he wants a plan. He's a homeowner. He has some assets. And he'd like a plan. He's a gentleman in his 80s and has multiple children. And this was one representative of the family that attended a webinar I gave and wanted to ask me some additional questions. So I said, sure, I'll give you any information that you need and we could speak about the issues and then set an appointment for her dad. He'll come in and we'll further discuss. A lot of adult children would like to set up a plan for their parents, and I could go a little bit and definitely provide all of the information to the family, but I need to know that the person that will be my client has the capacity, has the ability to make a plan, knows what they want to do, and is not unduly influenced. And one of the reasons that this parent was concerned, at least that was related to me, is because one of this person's siblings passed away under 40 years old. When you pass away at such a young age, unexpectedly, it makes you reconsider and consider, if you've never done it before, your life, your circumstances, what needs to be done, and how you set up the right plan or any plan at all for your family. Now, this person under 40, I was advised, had no plan, had some assets, and the family had to go through an administration proceeding. So that's why I say everyone needs a plan. even if you have a basic will, upon my passing, I'll leave everything to my spouse, if that's the case. Or, listen, I'll even give you this concession. With a spouse, it's easier. It's not easy. But if you're unmarried with no children, it becomes more difficult if you have no plan. You have to figure out where whatever you have goes. At least if you have a spouse, there's an identifiable person, and you're putting that person through a lot of grief, but it is easy. But a plan, a will. I'd like my house to go here. I'd like my bank account to go there. My pension. Some of these things have beneficiary designations, but some do not. You might be involved with a partner or a significant other, and you're not married, and your beneficiary designation says a parent. Maybe you really would have wanted that. So it at least involves a conversation. Where does the 401k go? Where does the IRA go? Where does the bank account go? Where does that, right? Let's figure it out. Slow, methodical process. Just make the inquiry. Then we figure it all out. We dot our I's and cross our T's. And so in speaking about the plan for the father, it was informed by the death of a child. We want to put something into place, plan when you can, so that when the time comes, if it ever comes, we all pass away at some time, whether it's tragically and unexpectedly, or at the end of a long life. Set it up while you have the ability to set up a plan, not banging on the table, not making it more dire or terrible than it is, but it really is an imposition on your family if you pass away without a plan. Put something in place, put some thought into it, and we'll make a plan. Take a look at the website, frankbrunolaw.com.